The process of pre-trial cross-examination is governed by the criminal procedure rules, and careful attention needs to be paid to the court's case management powers and the obligations of the parties. I would refer you to the Criminal Practice Directions 5, Evidence 18E, which must be followed where relevant and read in conjunction with this guidance. The guidance seeks to differentiate how Section 28 applications and processes are to be followed for the above cohort of complainants only. When Section 28 came into being, it was decided that a resident judge in each area could appoint a judicial lead from among the full-time judges at each respective court centre, who would be responsible for the monitoring and supervision of the scheme. The plea and pre-trial preparation hearing has to be conducted by a full-time judge, not a recorder, and it must be one authorised by the resident judge to sit on that class of cases, or someone who has been authorised to deal with Section 28 of the Youth Criminal Justice Act 1999 by the resident judge. So what was the thinking behind Section 28? Well, the rationale behind it was that those who were complainants in sexual abuse cases or in modern slavery cases should not have the case hanging over them for long periods of time before it came before the court. The idea was that the cross-examination can be captured quickly and easily, and that cross-examination could then be stored. I now turn to the ground rules hearing. In 2013, the ground rules hearings were recognised by the Criminal Practice Direction to be a vital link to the planning and conducting of proper questioning of a vulnerable witness or defendant. There are a number of courts that have different protocols for conducting the ground rules hearing. Many of the judges and advocates find them invaluable. They provide a framework and mechanism by which a judge can oversee the fair treatment of vulnerable witnesses and defendants. One of the first rules to bear in mind is that discussion of ground rules is required in all trials where there is to be an intermediary. And issues of questions have to be discussed between the judge or the magistrates and the intermediary, as well as the advocates, before the witness gives evidence. For example, an intermediary may say that the question is not clear or is not understandable to a child of a particular age, and one has to a large extent to be driven by what the intermediary says. As lawyers, sometimes we tend to embark on a form of questioning which can appear to a child to be quite convoluted and one that they don't really understand. The purpose of this legislation and the purpose of this guidance is to ensure that the child does understand, does know what is saying, and can answer in their own words any issues that may arise therefrom.